Good day, Crime Talk aficionados. It's Scott Reich from Crime Talk. That's right, it's Saturday. So what does that mean? It is a recap of all of our top stories throughout the week. And boy, was it a busy week. Frank's father and I, we all headed out to Idaho. Miss Julie went down to Salida and watched the Barry Morphew preliminary hearing. Great week. Don't forget to watch the top stories of the week. We'll see you next time on Crime Talk. We, here at Crime Talk, sent Julie, our young producer, down there to get in line early so that she could be in the courtroom. And guess where she is? That's right. She was there at 6 a.m. this morning, the second person in line. So she is in the courtroom taking copious notes and tweeting via Twitter. So if you have Twitter, go to Crime Talk with Scott Reich. There on Twitter, you can see her texts as they come through. Regarding what's taking place. Obviously, the big news of the day, it turns out a lot of people were suspicious of extramarital affairs in the Morphew matter. Apparently, Suzanne Morphew thought that Barry Morphew was having an affair, and as it turned out, that Suzanne Morphew had been engaged in an extramarital affair with someone that she has known from high school for at least 2 years. They have met at least 6 times. Over the last couple of years in various cities. Now that's the big news that came out. I think the significant thing is from that was that, well, first, no one said anything about it. Second of all, that the gentleman who was having an affair with her didn't come forward to the police until they contacted him. He didn't come forward when learning about Suzanne Morphew's disappearance. There was news about the bicycle, the way it was found, no indication that there were tracks going to where something may have taken place, no scuffle, nothing along those lines. I told you that I thought when you have to use a 152-page affidavit to establish probable cause, there's something in there that is problematic for the prosecution. Now, this is early in the stage and the burden is low for the prosecution, but these attorneys for Mr. Barry Morphew are very, very good. I told you they're coming out swinging. They are going to try and win this preliminary hearing, which means a first-degree murder charge doesn't stand. We've got today, tomorrow, and then 2 more days in a couple of weeks. It's going to be interesting. Next on the docket, Lori Vallow has a new attorney. Now, we talked about it in pretty good detail last week on our Tuesday Night Live show about the ABA standards for an attorney to be death qualified on a case where the death penalty would be sought. Clearly, Mr. Mark Means does not have those qualifications, frankly, not even close. And I opined that it wouldn't surprise me if there would be a new attorney appointed, and guess what? The judge has in fact done that. The judge, Stephen Boyce, appointed Jim Archibald on the case. Now, he apparently is a seasoned public defender, and he has now been appointed, and he is apparently one of the few death penalty certified attorneys in eastern Idaho. That is good. So he will more than likely become the lead counsel. Now, I think it's also very interesting that the court, even though these proceedings are stayed, appointed new counsel. Clearly, the court believes that Lori Vallow will be restored to competency, and let's have the attorney ready, willing, and able to proceed. Now, we checked the court website, and nothing about this appointment on the court website, but things seem to be moving rather slowly, and they don't seem to always give us as much information as well. Frankly, I think the public should know. Now, obviously, I don't know anything about Mr. Archibald other than what I've learned recently. Apparently very experienced, done death penalty cases, and is very seasoned defense attorney, which is good. We always want everyone accused of a crime to have a seasoned defense attorney for the simple reason that eliminates post-conviction issues down the road. Now, Mark Means is still listed as the lead counsel, but I don't think that is going to be lasting much longer. So if you watched our show yesterday, you knew that Frank and I, along with his father, jumped into Crime Talk 1, flew into the Idaho Falls Airport. Very nice FBO there. I think it was called Aramark Aviation. Top notch, treated us great facilities as well. Anyway, they were able to have a car waiting for us when we landed. We jumped in the rental car, drove up to Rexburg, checked things out. We're able to talk to some people in the community. And I'm telling you, nice community. Now, Madison County has some 40,000 residents. It's right there on the cusp of 40,000 people. I think they're going to be able to find a jury in that jurisdiction. I don't see a change of venue proceeding. The people that we were able to talk to while we were there yesterday in Rexburg seem to be aware of the case. I don't think they're following all of the details as maybe as our Crime Talk aficionados do. However, they basically have stated that they could listen to the evidence that's presented. And so we'll see what evidence is presented by the defense in their change of venue request. But at this point, I think they're going to be able to do it. Now, here's another thing. The Rexburg community, very nice. The city, the place is spotless. Not like oftentimes you see in the big city, so to speak. Madison County, which has Rexburg and another city that I can't remember at this time, but very nice, very clean. It looked like something out of Central Casting movie set, drop in, Western United States rural community. Nice as could be. And it seems like, at least all the people that we ran into, it seemed like every one of them would know how to operate a backhoe. And I don't mean that as in a derogatory way, because I wish I knew how to do that. I mean just people that just know how to work, follow the rules, and just very nice people. Frank, would you agree with that?
Yep.
All right. See, Frank agrees too. So, nice place. We'll probably be back in Idaho Falls. Rexburg had a little airport literally right in the center of town, but it didn't have a very long runway. I like long runways with control towers. So if we had to go in there, we could do it, but maybe next time. Yesterday was day 2 of the 4-day preliminary hearing scheduled for Barry Morphew. The other 2 days of the preliminary hearing aren't set for another couple of weeks. And as we stated yesterday, we had, that's right, producer Julie sitting in the courthouse both days. Now, a lot of people were in the comments saying, Scott, you need to look at this closer because, he drove his truck and made 5 trash runs, and that's sign of guilt. Okay. Preliminary hearing, the rules of evidence are relaxed. At trial, speculation about why the trash bags or items were stumped is speculation as to what was in them. And I said yesterday, I'm reserving judgment. We'll wait and see. But so far, there was no knockout punch by either side about this case. I'm looking for some sort of physical evidence that puts something to Barry Morphew in the house, in a car, and to date, we haven't seen it yet. Maybe it's forthcoming. We'll have to wait and see. But we thought it would be interesting for us to hear directly from Julie instead of me telling you what was there. So first of all, welcome, Julie.
Thank you. Thank you for having me.
Are you excited to be on this side of the
It's
the
weird,
camera?
but it's fun. And thank you so much for sending me. I had a really good time. I've
Okay.
never sat in on a trial, so that was a lot of fun doing that.
All right. Well, first of all, where was the preliminary hearing?
So it was in Salida. It was about a 3-hour drive from Denver, and it's a beautiful town. There's the mountains in the background. It's kind of what I would imagine Boulder would have been like 30 years ago.
Okay.
Just a fun town. I went and had dinner right on the river.
Okay.
Spent a little time in town kind of checking out what was going on.
What time did you get to the courthouse on Monday morning to make sure that you were actually in the courthouse so you didn't have to call back and say, Scott, I didn't get in?
Yeah, I wanted to make sure I got in. So I got there at 6, and I was the second person there. And there was another lady there from Estes Park, and she said she'd been there since 5.
Wow.
Yeah.
How many people were ultimately allowed in the courtroom when you were there?
The first day, I think they only allowed 8 in from the public and about 10 from the media.
Okay. And there was an overflow room somewhere where it was being piped into?
It was a few like blocks down, they said, at the fairgrounds, I guess. And they said that they might not even do that next time because when people got turned away at the courthouse, they didn't make their way down there for some reason. They just gave up. They only wanted the courthouse or nothing.
They just went home.
Yes, they went home.
Okay. So set the scene for us. What was it like? I mean, obviously the prosecution was there. Did they have a lot of exhibits? Was it all on, the computer? Same thing with the defense. Were they organized, disorganized? What was that like?
So I was in the probably 5th row back, and we had to do social distancing. So there was only probably 3 people per bench, and there was I think there was 4 people from the state, and then the 2 attorneys for Barry. Barry was sitting in the middle, and then they had some kind of assistant or some lady. And then on the other side was all the press, and then in the back was all the family, which included the 2 daughters, Barry's mother, and then a private investigator type person.
Was there any interaction between the prosecutors and Barry Morphew's daughters?
The prosecutors and Barry Morphew's daughters? Not that I saw, no.
Okay. And I think that's interesting because the defense wanted I think that's interesting because the defense attorneys didn't want the transcript or the affidavit released as it relates to why their dad is there, but yet they were clearly interacting with the defense attorneys and the defense investigator the entire time?
Yeah, the defense attorneys a few times gave the 2 daughters a hug, and there was a private investigator, I guess, there, and she was talking to the 2 daughters too. And Barry turned around and mouthed I love you a few times to the daughters, so there was a lot of interaction going there, but the prosecutors kind of kept their distance.
Okay. And so clearly from what you could tell, the daughters were on Team Barry for these proceedings?
It seemed like it, yeah.
Okay. How about Barry Morphew? Describe him. Was he in jail garb or did they dress him out?
So he was in a dark gray suit. He was a lot smaller than I pictured. I don't know why I pictured him being this big jock. I guess because he's been in jail for a while. He's lost a lot of his muscle mass. And his hair was not blonde anymore. It was white and kind of wispy and kind of cowlick in the back from what I could see. And then he had on cowboy boots that his pants were kind of haphazardly tucked in to his cowboy boots.
His pants were tucked into his
kind
cowboy
of,
boots?
yeah. It kind of looked intentional. He kind of thought it looked neater. I'm not sure. Yeah.
Yeah. Okay. Weird. Well, that's an interesting style for court, but you never know. There may be some sort of security reason or something. Who knows why they made him do that? Let's talk about the presentation of evidence. I mean, I read your notes that were pretty copious. I saw your tweets. I saw your tweets, and I saw some other people's tweets. Was there any big aha moment that you saw in there where people gasped or there was something going on there? I just didn't see a knockout punch.
Yeah, not really. The 2 moments that stuck out to me was at first when they revealed the affair that Suzanne was having. It wasn't really oh my gosh. It was just kind of, I think people kind of expected it. A lot of the locals might have known about it because they were just kind of knew that was going to come out. And I was shocked. And then the other thing that kind of stuck out was, I guess Barry was carrying a bunch of things into or out of the hotel room, and one of them was a blue shirt or a blue garment, and it's the same blue that she always wears. It's kind of a teal blue. And I thought that was a big deal, but then they kind of breezed right past it and didn't really dig too much into it, so maybe it wasn't anything.
Yeah, and you mentioned that to me before we got started, is that you thought that they were asking questions and really building up to something, and then they just kind of stopped, both sides, right?
Yeah, it felt like that. I was like, oh, now it's going to get juicy, and then they'd be no further questions. And I'm like, are they holding out on something? Or I don't know enough because I'm obviously not an attorney. But I was like, I thought we were going to drop a big bomb, and then they just move on to the next thing, kind of. And I didn't think of a lot of the text messages. I was like, oh, now it's going to get juicy, and then, okay, on to the next thing.
How were the prosecutors? Were they prepared? Were they, asking good questions, or were they disorganized?
I thought the prosecutors seemed really organized and they knew what they were doing. For the most part, it was Lindsay. What's his first name? Jeff, I think. Jeff Lindsay.
Just Mr. Lindsay.
Mr. Lindsay. He was mostly talking, and I thought he was pretty well prepared. And then for some reason, and again, I'm not a defense attorney, so I don't know, but I felt like the defense attorneys were kind of stumbling around with the exhibits. They'd say, oh, do you have Exhibit X? Do you have Exhibit Y? Oh, it's over here. Did I enter that already? Oh, okay, I did. And they did that like a few times throughout both days, which I thought was kind of interesting. Is that common? Is that?
Well, you usually try to have a pretty good idea of where the stuff is, but there's a lot of documents in this, so I could see the defense getting a bit of a pass on something like that. But no, I mean, clearly you like to look organized in your presentation, not only to the court and if there was a jury, but it also instills trust and confidence in your client if you're not fumbling around the courtroom, because it's obvious if you're not prepared.
There was a few times too where they drop kind of a bomb or not really, and I would look over and see if Barry like sat up straight or crossed his legs, and he didn't move like at all. There was a few times where he was like leaning like this, and then his attorney and him would be like, I think touching like shoulders because they were sitting so close, but he like barely moved, didn't really say anything except to his daughters. That was it.
Okay, and everyone had to wear masks in there, so were you able to see any facial expressions at all?
No, he couldn't see any facial expressions. He would pull his mask down to talk to his daughters before the breaks and ask them, like, how are you doing? How are you feeling today?
Okay.
Like questions like that, but that was it.
Now, were you able to talk to some of the locals? Did you get any juicy scoop on some of the locals? Where did Barry frequently like to go in town?
Yeah, so there was about 8 of us in the public, so we became kind of friends, and I just heard, I don't know if this is true or not, he would go to the gym, obviously, but then he'd also go to a salon and go tanning.
Like to get tan, okay. And you said his physical demeanor, you were surprised because all the photos he looked kind of big and buff, but obviously hadn't been able to hit the weights while he was in custody.
I don't know what I was expecting. I guess from the pictures you see he's like about to bust out of the shirts that he's wearing, and then I saw him in person and I was like, this is it? This is the guy that we're talking about? And it just didn't feel like that was him for some reason. It was just weird for me.
Okay. The people that showed up from the members of the public, could you tell, were they there to just kind of, look at it from both sides, listen, or were they committed to, supporting the prosecution, or was anybody there for the defense?
No, nobody was there for the defense. Most of the public was there. Team Suzanne, Justice for Suzanne, from what I know. And then there was a bunch of news reporters that were just reporting. And some of the news reporters, you could tell that they were also Team Suzanne. I don't think anybody was Team Barry except maybe the daughters and the mom.
Okay.
But yeah.
Well, and out of full disclosure, I mean, I think you had indicated at one point, oh my gosh, he so did it. Mm-hmm. But I've tried to keep you, no, you got to wait and see what comes down. After only 2 days, understand there's only been 2 days. They got 2 more days for the prosecution and the defense to cross-examine or present any evidence they choose to do so. Based upon what you've heard so far, just based not what you believe, but what you know, do you think the prosecution's made a case that would convince a jury ultimately a proof beyond a reasonable doubt?
I don't think so at all. There was really nothing. I was kind of trying to sit in it as a jury, if I was in the jury, and I was thinking like, okay, beyond a reasonable doubt. And there was not one thing where I was like, got him. And there was like one little part where they would say his cell phone was pinging throughout the house, and that was when he was most likely chasing her and she was unconscious. And then the defense fired right back and said that it wouldn't make any sense because each ping there was like a 1 second, so he'd have to be traveling 30 miles an hour. So I was like, I don't know how this makes sense then. That can't be possible. So that was the only thing that I was like, gotcha, and then, oh, maybe not.
And that's why you have to wait and see for cross-examination, because remember, the prosecutors are advocates for their side, and it's not their job to present all the evidence. That's why the defense has to bring it out. And, it's amazing the amount of information that they had between telephones, card data from the
Yeah.
little black box in the F-350 truck, I think, that he has.
Surveillance video, text messages.
iClouds, Bobcat GPSs, and the prosecutors agreed, or the witnesses for the prosecution agreed, that the Bobcat had nothing to do with this
it.
case.
Yeah, I know.
And so was there any talk? Did you overhear any scuttlebutt? Anything in the courtroom? All the juicy stuff? Like the prosecutor saying, oh, just wait. It's coming. Anything like that?
Not really, no. And I'm a very nosy person by nature, so I was
Which is why we hired her.
I was like sneaking up next to the state, kind of like trying to listen in, and they're not going to talk loud enough for me to hear. But if I could catch anything, and I couldn't hear them saying anything, just wait, or no reassurance to anybody around. They just kind of walked in, walked out. They didn't talk to anybody, didn't talk to the press. It was just strictly business that day.
What was the interaction like between the prosecutors and the defense attorneys? Were they amicable, or has it already turned professional but hostile?
I think, yeah, professional but hostile. Like, they would ask a question, and then there'd be an objection, and then they'd whip their head around, and, well, it's relevant because, and then, like, kind of, so it was still professional, but I was kind of like, ooh, like, and I watch attorneys, and I have so much respect because I would just go up there and start crying if somebody yelled at me like that.
Yeah, you can't take it personal.
Yeah, exactly.
You're just doing your job.
But
yeah, so it sounds like the prosecutors were getting a little tired with the objections, and then
And
well,
there was
it's
a
relevant
lot of
because of this.
repetition, the text messages. Did Barry know about the affair was asked like a dozen times, and the prosecution was like, enough. We asked this 20 times. Like, we get it. So
what was your take? And like I said, not being an attorney, not having attended a lot of court appearances, what was your take on the judge? Was he in charge of the courtroom, or were the defense attorneys or the prosecutors really in charge?
I don't know. I guess kind of both. He did a good job. He kept track of how much time, like down to the minute, each side has used, which I thought was a good idea, because now he's saying for the next 2 days, the defense has an hour and a half less because they used an hour and a half more this first time. But there was a few times where I felt, and I don't know, but I felt like he was kind of, let the defense say their piece, let them finish. And he was kind of leaning towards the defense, let them say their side. And I was like, I don't think we got the same, but I don't know.
Well, the judge has to, he has to balance,
Sure, yeah.
obviously the rules of evidence, which are relaxed at a preliminary hearing, where you can bring in a lot of hearsay evidence that would not otherwise be admissible at trial. Which brings me to a lot of these text messages. You got some hearsay objections at a trial for sure. So we'll see. Obviously, the standard is very low at a preliminary hearing. It's simply probable cause. All the evidence needs to be viewed in the light most favorable to the prosecution. So we'll wait and see. So make your hotel reservation for the next 2 days of the preliminary hearing, and don't forget to submit your expense report. All right?
Sounds good.
All right.
I'll be back, August 25th?
25th, and we'll take a quick recess before we continue with the rest of the docket. Please go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. Why Mark Means has got to go. Now, as we talked about the other day, the court, on its own motion, appointed a new attorney for Lori Vallow. His name is James Archibald. We talked about him the other night. He is an experienced criminal defense attorney and has been a public defender, so he knows the system, and he's handled several serious cases, and he's one of the few attorneys that is death qualified. And I mean death qualified in the sense that he's done death penalty cases there in eastern Idaho. It would make sense that he would be the lead attorney on this case from here on out. Mark Means should simply sit down, shut up, and please don't say a word, and pretty please don't file any more motions. And that is what brings us today to why he has to go. As I was looking at the new motions filed by Mr. Means, I literally want to just shake my head and say, this is why people don't like attorneys. This is why people don't like attorneys, because they think they file frivolous crap motions that have no basis in the law or fact, and therefore they file crap. If the court was concerned about Mr. Means being able to handle a complex criminal case, this should be Exhibit A in that order and motion. Mark Means filed a motion dated August 11th, and it's captioned, "Declared motion to dismiss the grand jury indictment." Well, I'm figuring a motion to dismiss the grand jury indictment, there must be some error in the grand jury indictment, something that was done improper which would throw it out. Oh, no. Mark Means came up with a novel idea, one that I don't think anyone would have thought of except for Mark Means. Why is he asking for the grand jury indictment, right? A grand jury indictment alleging murders of Lori Vallow's 2 children and the involvement with the death of Tammy Daybell, right? Pretty serious. You think a court's going to dismiss that unless it is outright totally egregious? No, they're not. They're not. Well, Mr. Means says he wants the proceedings dismissed against his client, dismiss the indictment. Why? Because he says that the prosecutor attempted to set a date in this matter, knowing full well that these matters were stayed because Lori Vallow was going off to the state hospital to be restored to competency. He states that there is no plausible argument regarding this blatant violation of the court orders to stay the proceedings, and that conduct was in direct violation of the court's orders to stay the warrant issue of dismissal of the above case. And he wants sanctions, right? He wants sanctions. He wants costs and fees to be issued against the state. Okay, let me tell you something. First of all, the appearance, although it's never really referenced as to what appearance he's referring to, one would have to assume it was the first appearance where Lori Vallow had been found not competent in the other proceedings regarding the tampering with evidence case, that's where it was stayed. The new case, which would have been the first advisement saying there's an indictment alleging all these new charges, you may recall we put that up for you as it related to Chad Daybell, that was the proceedings. There was nothing at that point issued in this particular case staying those proceedings until that time. The state did nothing wrong, in my opinion. And to ask for costs and fees associated with this is absolutely ridiculous. Okay, Mr. Means, I have never seen fees imposed against a defense counsel, let alone a prosecutor, for conducting business before the court. Not in a criminal case. Never a prosecutor. Never, ever a prosecutor. But this is the kind of stuff, the games that people play when it comes to civil work. And yes, my firm does civil work. And I'll be honest with you, I hate civil work. Why? Because this is the example of what civil litigators do oftentimes. It's always looking for a gotcha against the other side to try and ask for costs and attorney's fees to be imposed. You don't do that in the criminal world. It just doesn't work that way. And there's nothing that would warrant the dismissal of the indictment based upon this argument. In fact, Mr. Means cites no authority whatsoever that would state that this was in violation of anything other than he says is the court order, or any authority given the court the authority to dismiss the indictment. Indictments are dismissed for errors in the proceedings themselves or if they lack probable cause. Those are the only reasons why they would be dismissed. Mr. Means has no clue what he's doing, and he needs to get off this case. Hopefully, Mr. Archibald will come in and say, I'm in charge now. Sit down, shut up. You are basically qualified to get me a cup of coffee. That would be about it. And not to be outdone by that frivolous motion, Mark Means has filed additional motions to compel the prosecution to comply with his Rule 16 requests. And guess what? Well, those proceedings have been stayed, Mr. Means. And once again, it's the same issue where he simply has to go and pick up the discovery. I'm not sure what Mr. Means thinks he is accomplishing by this. He has some free time on his hands, apparently. Maybe spend a little less time allegedly visiting the state hospital and maybe a little more time trying to get the discovery so he can assess the case against his client. Mr. Means needs to go. Next on the docket, do you remember the guy that was caught on video, not once, but twice, going into the home and the bedroom of Cash Gurnon in Dallas and kidnapping young Cash and then ultimately killing Cash? That's right. Darian Ronnelle Brown. He was formally indicted Monday by a Dallas County grand jury for the slaying of Cash Gurnon. It is obviously a capital offense. Now, we have shown this video, but I think it's maybe worth showing just once again. Look how Mr. Brown goes into the room, into the house that is not his, and he has no reason to be there. And he literally plucks this child from his bed. Be afraid, ladies and gentlemen. You have to take care of your family. You have to look out for them because the police are not going to be there to say, hey, what are you doing going into that house that's not yours? They're not going to do anything. They show up later and put the little markings and the yellow tape up around the crime scene. You have to take care of yourself. And ladies and gentlemen, as a criminal defense attorney, I'm telling you, there are a lot of bad people in the world, and you don't always know what they look like. What does a bad man or a bad woman look like? You don't. So you got to trust but verify. And what's even creepier with this guy is that he goes back not once, but twice and actually considers taking Cash's other brother from the house as well. Gruesome case. Have a wonderful day. We'll see you next time on Crime Talk.